Okay, hello everybody. We're back, and today we're going to go through the messy case of Rose v. Rose. And I want to start off by telling you we can fix your problem. If they used one dime of your veteran benefits to calculate a support award in order to steal the money that is supposed to go to your child, you can get them back. You can get your money back, and you can force them to do their job and provide the federal benefits to your child that they're supposed to be providing. And this is how we're going to do it. The problem that a lot of people face when you guys walk into these courts and the way they abuse you, the way they extort the money out of you, is they try to tell you they have a Supreme Court precedent that says they're allowed to do it. And they quote the case of Rose v. Rose. Now, here's an important thing about Supreme Court precedents. There's a Supreme Court ruling that says that black people are nothing better than cows and they can be sent back to the South. Okay? Laws change. So the Supreme Court's precedent that they set is, there's kind of two parts to it. There's the part where they say, okay, when Congress writes the law, because Congress writes the law, they say when they write the law and it says this, in this situation, we read it like this. This is how it's interpreted. This is how you take Congress's law and use it. And it can be used differently in different situations. So, for example, one thing that they held in Rose is that when you're dealing with waivers of sovereignty, which is what veteran benefits are, it's the ability of a veteran and their child or their family or whoever to sue the United States for money because you have a waiver of sovereign indemnity. The United States, otherwise, it's a sovereign country. The state is a sovereign country. You have to have a waiver to sue through sovereign indemnity. Okay? So, you're suing the United States for money. You have this ability to do this. There you go. When you read the laws on jurisdiction, they are read strictly. The Supreme Court's held this. Now, I don't care if you're talking about Social Security jurisdiction. I don't care if you're talking about military retirement. I don't care if you're talking about railroad. If you're talking about the waivers of sovereignty somewhere where the Congress has said you're allowed to sue the United States for money, anytime you read those jurisdiction statements, they're read strictly. There you go. It's still valid. All right? So Rose is a very valid case. There were actually two rulings. One is a ruling called Wisner, and it was Wisner versus Wisner in 1950, and the other one was Rose v. Rose in 1987. And the only reason we have two different rulings is the first time the Supreme Court said, look, when the law looks like this, you're not allowed to do it. And then in 1987, they said, when the law looks like this, you can, but just like in Wisner, if the law doesn't look like this, you can't. So that's how they reconciled that Wisner and Rose are still good law. They're saying, look, we're not overturning our old precedent. We're not saying you interpret law differently now. We're not saying that the rules changed. We're just saying, okay, what we said back then was true because the law was different. Today, it's still true. So when we explain, we say, okay, here's now an example of what law can look like when the states are allowed to. Well, the state courts want to pretend that it's still 1987. They want to pretend that Congress has not written or changed or done anything since 1987, when in fact, Congress looked at that ruling and went, oh my God, they have authority over our sovereignty. No, you don't hand a state a blank checkbook and say you can do anything you want with the U.S. Treasury money. You don't hand the states this and that and the other. When we want to give the states money from the federal treasury, we assign that money and say, here, we're giving you this money. Now you can make decisions about it. No, we do not tell you you make decisions about money coming directly out of the, oh, no, 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 no. So Congress very quickly changed it. There was actually two cases. Rose v. Rose was the first, and it was a very big one for veterans. And then the second one was a case called Turner. that happened the following year, and they just said, Congress said, okay, we're going to do it. And the Rose case was veterans banging on the doors of congressmen saying, we need to change this. This is messed up. We've known about this problem for 35 years. We want this changed. And then they did the second case and they went, all right, you're right. The whole thing's screwed up. We got to fix it. Okay. So this is a direct response by Congress, almost an immediate response, in fact, by Congress to fix this problem. Okay. And so we're gonna talk about how Rose went through, and what they're using against you is actually what saves you. Okay. And this is what I've put in the sample brief. So if they've used your money in a support award, remember, we signed the original deal. It's part of the new deal by FDR. It was added into the Constitution because they didn't want to stick by the deal. See, before the Civil War, they said, I don't care about your original deal in a written contract. We can ignore it because of sovereign indemnity. And so when we had the Civil War, we went, no, you're not going to ignore this. Section 4, the 14th Amendment, our equality is guaranteed. The debt to veterans is guaranteed and shall not be questioned, period. No ifs, ands, or buts. And by the way, it includes all the stuff that happened before. I've had a lot of people sit there, oh, that just means for Civil War. No, it says it includes it. It's retroactive. The Constitution is a forward-speaking document. So this is guaranteed, all right? You're guaranteed that if you lose the ability to participate in the economy for any reason, the United States is responsible for providing you a support award, for providing your family a support award. This is kind of like a bankruptcy. You have been wiped clean of your family obligation debt. You had a financial debt to your family. It's wiped clean. And it's unlike a bankruptcy that the United States instead assumes the culpability. It is now the United States' job. They have taken over your financial obligation to provide support awards for yourself and your family because you gave up all your rights in order to protect everyone else and this economy that they love to profit in. So you get a right to at least survive in it. And your family has a right to survive in it. And we're going to make sure that happens. So what we have in Rose is when you're dealing with giving our government a job, and that's what this is. This is a job. We've told them they're going to take care of veterans and their families. Okay? And part of the job is under the VA, and the other part is under the Department of Health and Human Services. And the Department of Health and Human Services pushes money to the state, and then the state does a lot of the accounting for us. We kind of outsource to them, like a third-party outsource for your company, kind of like they talk about sending all the stuff to India and whatever, and people get mad about that. That's what that is. We're outsourcing the administration and the benefits and giving out the money for your kids to the state. The same state that's doing this thing where they're stealing your benefits to do it because you get your money directly from the federal government under a waiver of sovereignty. It's not handed to them and said, okay, give it to these people. No, 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 no. The United States makes these decisions. Now, the way this works, and most people talk about the law, Title 38, 5301. So we have Title 38, United States Code, U.S.C. 5301. Okay? This is a really great law. Okay? And people forget what the point of this law is and the purpose of this law. They look at it and they go, it's an anti-attachment law, which means that creditors can't come and take your money. That's all it is. No, this is an anti-corruption statute. Okay? This is not like some, oh, get out of jail free, you don't have to pay child support, you don't have to take care of your kids, you don't have to do this and that and the other. This is not something like that. Sorry about that. So, this is an anti-corruption statute. Very simply put, okay, in all the language it says, okay, and it is thorough. It is super, super thorough. So when we talk about jurisdiction, it's kind of like you're saying we're setting up a wall or a fence around your property and you're saying, this is mine, okay? But we're doing it as part of giving somebody a job at the federal government. We're saying, here's a bunch of money, go do a job. Here's a bunch of money, United States Attorney General, go do a job and take care of the DOJ. DOJ, this is your money. You have this job. VA, this is your job. This is your money. You're going to do this job. This is your jurisdiction. This is your house. Okay? This is your veteran benefit house. You're going to make the decisions here. Okay? And it's all about making decisions or reviewing a decision. And so the first thing is I want you to think about this like programming language. Okay? I didn't do law before I did all of this. I actually did computers. So actually doing this became exceptionally easy for me to kind of transition and figure out. And why I'm trying to help you with it is a lot of people can't transition to figuring this out. It's just a different language. It's code. United States code. It's not C#. It's not Visual Basic. They have procedures, just like computers. It's just written in legal English, not common English, not slang English, not casual English. It's written in legal English, which means that sometimes words don't mean the same thing. In a court, you could say, I want a continuance. If I told you today, hey, let's continue building the fence, you'd say, okay, we're going to keep going. Well, in court, you're not going to keep going. You're actually saying, I want to stop. I want to stop right now. We're going to continuance because we're going to do this later. We are going to continue later, but we're going to stop right now. So it's not quite the same. So there's little differences in what the language is, and they get very specific on what their words means. And they don't follow the culture of people saying, okay, well, we're going to change the word this and that and the other. Like I'll use the word retard. Well, back in the old days, the word retard was anybody with a mental deficiency. They were diagnosed. It was in the medical books. You're a retard because you have this. And when you wanted to defamate somebody and call them a retard, you were defamating them, saying you're a retard because you're being stupid on purpose, and you're just like these people who can't help it because they have a physical problem or they're deaf and blind or some other thing that you're putting down all these people saying they're terrible. This person's terrible, but you're comparing them to these people. Well, guess what? Today, we have the DSM-5. There is not the word retarded in there. It's no longer a diagnosis. So these people, they're no longer diagnosed as retarded. They have autism, they have MS, they have some disease, they have Asperger's, they have something. They're not retarded. There's no more retarded people in the world except, well, Democrats. Sorry. They're retarded. Those are the retards. If you do something and it's purposely stupid and you don't have one of these conditions where you're diagnosed as having some other problem and issue because of a very legitimate reason, and you're doing it and you don't have that, retard. Yeah, that's how it works. So that word didn't change. You know, in culture today, we now use that term just for these people. We're not using it to refer to these people. Well, in law, they don't change definitions. Things can't shift by culture. None of that stuff. Words are the same. Continuance is continuance. I don't care if, you know, culture wants to say this. There's a bunch of words that, you know, 30 years ago now mean something different. Well, legally, they don't do that. They don't change it. It stays. So let's get back to this. We're going to deal with the very strict language. When we look at this, 5301, anti-corruption. So it's if and then else statements. Okay? And what 5301 says is it says if you have authority. So if authority exists, you can only do what the law says. Okay? So if it's your job, okay, to do this, you can only do what the law says. So, for example, the law says that the VA can give people benefits. And for retirees, there's a dental program that has a premium. And some of the retirees said, well, I want you to instead of making, you know, handing me my veteran benefits and then me paying you the premium cost, why don't you just automatically deduct it out of my veteran benefits and then send me what's left? Why can't you do that? That would save so much time and processing, because it's not in the law. The VA can't do it. They're not authorized to do it. So they are blocked by 5301. It prevents them from doing something they're not allowed to do. It's corruption. They're trying to stop corruption. So if you have authority, you can only do what the law says. If you don't have authority, you can't do anything. And I've said this before. You can't piss in the general direction of these benefits, okay? You can't even look at them screwy. You can't look at them at all, okay? You can't touch them. You can't do anything, whatever. The word whatever is actually in the law. I have never really seen this anywhere else where they got there and go, you can't do this, 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 nothing, this, can't do this, 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 whatever. You can't do anything whatsoever. If you don't have authority whatsoever. This law, this is the barbed wire on the jurisdiction fence. This is the nasty barbed wire that keeps everybody under control. It's not what says where the fence goes. It's the barbed wire on the top that smacks people around. It's anti-corruption. It keeps people from breaking the law and crossing that fence when they're not supposed to. So if you don't have any authority, you can't do nothing. Nothing at all, okay? Not only that, but there's a very important part of this law that people forget that's in there. And that is that they said that if anybody does do something under here, this is a very big thing under the law. It's void, okay? When you go to court and you say, okay, they didn't do the law right. They were allowed to make a decision. Okay, we told them it's your job to decide this agreement. Me and my neighbor are having an argument. We don't agree on where the fence property line is. We disagree. We get a bunch of evidence. We go to court. The judge is going to settle that agreement and say it's right here. He's settling that agreement by making a decision that settles the disagreement between you and the VA or you and your neighbor or you and someone else. He's settling an agreement. Any type of agreement, any judgment, decision, any void from its inception, it's not legal. It's gone. It's illegal. So if a judge had authority to make a decision and they do it wrong, that's what's called erroneous. And that's when you can have it corrected. You can appeal that decision, and that's the process to deal with an erroneous decision. It might be voidable. Congress might say, well, if you violate this law, then it can be voided for up to 1 year. So, for example, if the judge is allowed to do this, it's a bad decision. You have 1 year to get it corrected. Otherwise, we're not going to put it back in the court to argue over it. You waited too long. It's like a statute of limitations. It's voidable. Okay, it can be voided, but you still have to go to the court and say, I need you to fix your mistake. You made an erroneous decision. I need you to fix this. You made an erroneous decision that is voidable. I need you to void this and vacate that ruling because it's allowed to be voided. Congress said that you can void this and you should void it. As a matter of fact, they might say you have to void it. And it must be voided if it's void within 1 year, and then afterwards you can't. I'm within 1 year, I can do this. You're after a year. I'm sorry, we can't. I know the law says that we can do that, but it's only beforehand. So, but this is different. This doesn't say that a judge needs to void the ruling. Congress voided it. It says void from inception. This means very specifically, you're not going to court. When you come to protect veteran benefits, you get a copy of the sample brief. You send that to the judge. You're not asking the judge, hey, judge, I need you to void your ruling. All the way back to 5 years ago when you made it. Statute of limitations, something. No, no. Congress already voided it. It's gone. It's void. It's illegal. So from inception, it's gone. You don't need a court to do it. No, you can ignore it. And Congress has done a bunch of different things. It used to be you had to go back to court in order to say these are void. We don't have to follow them on a whole number of different things where courts were sending garnishments to people and taking their money. And Congress wrote a whole bunch of rules. And they let the banks know, because the banks were like, look, we're stuck in the middle. We got these poor people. They don't have any money. And they're yelling at us because we followed an order that's void. But we don't know it's void. We have no way of knowing it's void. Well, they gave the banks a way to know that it's a void ruling. So the banks, guess what they do? They get a garnishment order. Now, normally, if they don't know it's void, they have to follow it. They don't decide whether they can't review it. They can't do nothing. But if they're told by Congress in the statute that it is in fact already void, they don't have to follow it. but they do have to tell the court. And that's what we're going to do with this brief that we're giving the court, is we're giving the court notice. We're telling them, we're not asking you to void this. It's void. I just have to tell you this because you're enforcing it, and as long as you're forcing it, you're acting without authority and you have no robe. So I would like you to not rip your robe off right now. You need to, realize that you've been voided by Congress. And if you keep doing this, now you know you're acting without authority. Now your robe is gone. You can make mistakes, but as soon as I show you this, no, your robe disappears if you don't stop. It's gone. Okay? It's torn off, gone. This is void. Okay? So you have to tell them. Right now, you can't just rip their robe. You can't go, I want to break my thumb, they made a mistake, they did this and that. No. Do this. People keep asking me, Pete, what did you do why is it that you have a right now? How did you get into a situation where you completed so many steps that you actually are authorized right now? I realize, and I keep telling people, I'm not doing that. I could take up arms against Oregon. I could go do that. Well, it's because I did all of these steps through all three branches. Now, I'm not going to give you a checklist. I told you guys this. It's like I'm not going to give you a bomb-making recipe on the frickin' site. Just because I know how to make a bomb doesn't mean I'm going to show you how. Doesn't mean I'm going to sit there and make one and go use it. Just because I can doesn't mean it should. I'm going to do this peacefully. We're going to do this the right way. We're not going to resort to violence. Okay? I want you to do that, so I'm going to give you all the ability to do it. And that's why I'm doing this. So, you want to rip off their robes. Again, go to Protect Veteran Benefits. The video's from them. Go there. Front of the page, it says Contact Us. Okay? First, I would really like it if you would share this, because I've got guys all over the place who do not know. I got a guy yesterday who responded to something. I was talking to somebody else, and he goes, "Wait a minute, you're saying that?" And I was like, "Yeah." He goes, "Can I talk to you, maybe on the phone and stuff? Because this isn't even my real name. I'm hiding because the courts are after me." These guys are hiding. I need your help getting this information out. If you're seeing this and you're not hiding, just think about the guy who's being threatened and extorted. These are illegal orders. They are seizing money from the U.S. Treasury. They are extorting these people. They are threatening them with prison unlawfully. We have to look out for each other. And so I would really appreciate it when you're sending this out there. Say, get the brief, get this. Go to the page, like it, so that you know what the updates are, and that you get videos and update information like this, and then share it with all kinds of people if you can. Then go to the group. Click the Contact Me page. That goes to Facebook, but it's the group pages that Facebook has, and they let us publish documents, and pinned right to the top. And you don't have to join the group. You can if you like. We do discussions in there, and we can, people, might need some help filling stuff out or answering some questions on how to fill out some stuff, because you've got to do the work. You have to actually put your information in there to say, this applies to me, okay? I can't do everything. I can give you a sample brief that has this information in it, all right? That's what I can do. You give them this, but you write your name on it. You write the court. You do this. I can give you something that's in a pretty good format, It's marked as a motion to show cause, which is a good way to, it's a standardized method that every court recognizes to open up a question to the court to tell them to do something. You can't just submit an affidavit. You can't just submit a this or that and the other. You have to tell the court you have to do something. So that's what this is addressed as. It says, court, do something. And you're telling them, stop enforcing a void order. That's what you're doing. All right? So you got to submit this in a format like this. If you have a lawyer, that's awesome, because you can get a guy who can understand this and really explain it to the judge, because the judge likes to get explanations. You don't have to do that. You just give them the brief. It's all in there. It's like sitting there and going, dude, the writing's right here in the book. I don't have to explain it to you. You're the one who's a judicial doctorate, for crying out loud. You have literally a judicial doctorate to practice law, just like doctors get a doctorate to practice medicine. These guys get a judicial doctorate. You should be able to read this. If you can't read this and understand this, then guess what? You're incompetent and shouldn't be wearing that robe anyway. So either way, I've given you the information to where that robe comes off if you don't stop, okay? So this is the other part, because you can't just show them a lot of times just the language, okay? You do also, it helps to show the other parts of law, which is the case law history, it is the ruling history, and that's what we're going through here. So we have this law, and it does this work, but you have to show more than just this one, because this has if-then statements in it, and we have to show the if parts. So if authority, if not authority. Well, where is authority defined? Who defined the brick wall? Under Title 38, in the Rose v. Rose case, so we're going to explain this from the past to now. We're going to talk about how it looked when Mr. Rose walked into the court. When Mr. Rose walked into the court, he actually didn't argue whether or not they could use the benefits in establishment. He didn't argue that because they had already gone through this and they said, no, we have it. And he goes, yeah, I can't fight that part. They pretty much have it. But I'm going to fight the enforcement part. These are two separate processes. They're covered by two different laws. They are blocked by 5301. They're both blocked by this. Okay, they both use barbed wire to protect things, but establishing a benefit award versus enforcing a benefit award are two different things. If you owe a credit card money and they want to get it from you, the first thing they do is they file in court to say this is a valid debt. And they get a judgment to say this is a real debt. They have to establish that it's legally a real debt. Then they can ask for a garnishment. So two different things, two different sets of laws. And this is where the courts will try to trip you up too, because they'll conflate it and try to say that this is this and this is this and it's the same thing. No. Two very different processes. The first law that existed was this law called Title 38. This was the jurisdiction statement for the VA. Now, I talked before about corruption. I never did make the video about how, I explained how the New Deal went, where we now share our federal benefits with everybody else. I explained that in a previous video, so that we created benefits for our family. We shared them with everybody else in the state. We were going to let the state make the decisions administratively, how it's block funds, all that good stuff, and how they're supposed to be giving the support awards, these federal benefit support awards to our kids. That was a leftover failure from FDR. FDR tried to steal the money. The first thing he did, he promised us the New Deal. We loved it. It's a great idea. Help save America. Help everybody. We love helping everybody. But as soon as we gave him the authority, he walked off with all the money. He stole it. That's what Democrats do. They love to steal all the money. That's all they want. They just want access to those federal benefits because that's how they profit. So he just walked off with it, and we put it back and walked off. Well, this is one of the failures of him trying to make it so that he could steal the money. This ended up causing a huge problem. All right, so we have Title 38, United States Code 211. Okay, and the Supreme Court, when Rose went to the Supreme Court, he had told the appeals court, hey, this is void under 5301. You're void. You're acting without authority, according to what I'm reading here. They're saying what we're reading doesn't say that we don't have authority. We're allowed to do it. We can do it as long as it's in the law. There is a law that says we're allowed to make a decision between veterans and their children and who gets how much. Okay? And we're just making a who gets how much decision. And since we're authorized, we're following a law. We're not doing something the law doesn't say we can do. The law says you can make a decision about how much kids get and how much veterans get. That's provisioning benefits. That's providing benefits. We're doing it. So we're doing the law. We're not messing with the barbed wire. We're not doing something the law doesn't say can't be done. So they argued over this whole thing. Well, the Supreme Court, when they looked at it, when you're talking about a void ruling, and you're talking about a debt like this, whether it's a family financial debt or any kind of debt, you're talking about you have to deal with both how it was established before you deal with enforcement. Again, establish it, then you enforce it. So they had to look at how far back it was void from inception, because this says it's void from the beginning. So where is the beginning of when it became void? So they said first we have to look at establishment, and establishing a benefit award of who gets how much is the jurisdiction of benefit decision. So that's this is establishment. And then we're going to cover enforcement, that separate process too. So they covered both, okay? Even though he was only arguing enforcement, they had to look at both. They looked at both, and they explained it thoroughly. And they explained it both ways. They said, okay, Title 38-11. What does Title 38-11 say? It said, decisions of the admin, decisions of the administrator are final, and it has to do with providing benefits to veterans, their family, and survivors. Okay, so for providing benefits to families and survivors, giving these federal benefit support awards to families and survivors, all the decisions providing cannot be reviewed, and this is a big one, reviewed by courts and officials of the United States. I've shortened this a lot, but it's 3 very specific points that the Supreme Court ripped Congress a new one for leaving this like this after FDR did his whole thing. Okay? They tore this up. They said, first of all, we are talking about waivers of sovereignty. And when you read waivers of sovereignty, you must do that strictly. Okay? Now think about that. You can have a case changed or all kinds of stuff. That's interpretive law. That's a decision that the court says you have to do it this way. I don't care if you're talking about railroad retirement, any kind of waiver has to be read strictly. Okay, so the Supreme Court's already ruled this. Okay, now when they read this law, they said, okay, well, first of all, does this say anything about making a decision, or does it only talk about who checks that person's decisions? There's nothing in here saying the VA has to make a decision. We gave them all this money and they don't have to do anything. They said, this was one of the first things they said. First of all, there's an assumption of jurisdiction that anyone can make a benefit decision. Anyone. And unless Congress says these decisions to be made are specifically to be done by this, anybody can make these decisions. Anybody can. So this doesn't cover making decisions at all. Anybody can make a decision. So the court was right when Rose got in there. He says, I can't argue this. Everybody can make a decision. I can't argue that. So that's why he wasn't arguing establishment. He was only arguing the enforcement. Okay? And the court goes through and they read it some more and they said, okay, so first of all, anybody can make a decision, but this does limit the review of decisions that are made by the secretary. When you're reading law, I want you to think about this. Lawyers are 2-year-olds. If you tell your kid you can't put your hand in the cookie jar, your kid is going to take the cookie jar and dump it out and say, I didn't put my hand in the cookie jar, and eat all the cookies. Okay? Lawyers are 2-year-olds. They're going to get those cookies any way they can. You have to be specific and you have to deny them directly and say you cannot eat the cookies. So I don't care if you knock it off the table and it breaks and you steal the cookies. I don't care if you dump it out. I don't care what you're doing. You can't do it. So there's a very specific part of law that says you cannot do indirectly that which you've been prohibited from doing directly. Once they directly prohibit, now you can't go all over the place and try to sneak access to the cookies. If you made some stupid comments and just keep your hands out of the cookie jar, fine. I didn't put my hands in the cookie jar. I just dumped it out. Okay? Lawyers are 2-year-olds. Okay? That's how they argue. Semantics. We all become 2-year-olds once in a while and argue semantics, but that's what it is. They take things very literally. All right. So they said this does a review. Now, the VA in Rose's case did decide. They made a decision. They gave him some benefits. They said, Rose gets these benefits. So there was actually a decision. But because there was nothing about making a decision, the states were allowed to make an independent decision. They could make one. They weren't making the VA's decision. They weren't reviewing it either. They just made their own up. They just made a new one. And they said because there's nothing controlling making a decision, anybody can make a new decision. Guy in the street could say, I want to make a new decision on who gets how much in benefits. That is crazy. Imagine why Congress responded to this case. So the second thing they said is So let's look at the review. So if the administrator got off his fat butt and decided to make a decision, what decisions are we controlling? What decisions are we saying cannot be messed with? Well, providing. That's just eligibility. That's not who gets how much. That's just who. And the VA had made a decision that, yes, these benefits are for the veteran. He got benefits for him, and he got a couple extra dollars, like I think it was like $13 or $40 or something like that extra. Today, it's like $100 at most. It's not the majority of benefits for your kid. It's a tiny amount because you need help being a parent. But, you know, the main benefits for your kid, Department of Health and Human Services, these are over here. If you have a kid, they need a stroller, Department of Health and Human Services gets you a stroller. If you're a veteran and you need a wheelchair, that's coming out of the Department of Veteran Affairs. Now, you're a parent of that kid in a stroller, you can't push that stroller if you need a wheelchair. So they give you a little bit of extra money for your family so that you can buy an attachment to your wheelchair to push a stroller. That's what that money is, okay? And the problem is that you have money that doesn't keep up with the cost of living. They just don't. So most veterans really need every last dime just to care for themselves, even the money they give you for the attachment. It's not keeping up with it. You're needing more, okay? When they're doing this decision on whether or not they can give some money to the kid, when the VA is making the decision, they're looking at your situation and saying, well, on average, a person who is rated at this much needs this much money. There are people with more. There are people who don't need quite as much, but the average was right here, and we came up with this number, and this is how much everybody gets. They're checking to see if you're on this side of the line. If you don't need that much, then they can give some money to the kid, and then that money, when the kid walks into the TANF office, half of it can be used to prevent them from getting TANF. So if the kid was supposed to get $100 in TANF and the VA is able to give him $50, then only 25 of it comes out of the 100, so TANF gives him 75. Yes, we have a constitutional right to the federal benefits. Our kids are going to get a little bit more than everybody else, just because they stretch it for everybody else to try to help more people. We're doing the best we can. Come on, it's a handout, all right? We came home, we've got benefits. We are getting our support award, but we don't like to see starving kids, so we're handing a couple bucks out. That doesn't mean you get to come take over our house, all right, and kick us out of it, all right? We want to help. We want to help. We don't like seeing you starve. Don't sit there and turn around and get mean to us and try to steal it all. So, they said just who. Providing is who. If he gets off his fat butt and says, yeah, the kid should get benefits, not writing a check, not saying how much the kid should get, if they say who, somebody else can't review that decision. And who can't review it? Courts and officials of the United States. Now you're being specific. It's not just all courts and officials everywhere in the United States, just the ones of the United States, okay? They didn't say it was any court and any official. They just said, it's like saying, you can't go anywhere in my master bedroom. That doesn't say you can't go in my house. That just says you can't go in the master bedroom. You can't go in. So, yeah, you're being specific. So, if he got off his fat butt, deciding who is allowed to have benefits, forget about writing the check. Forget about getting money and how much they get. So, you don't like the idea that, you know, the VA said that this person and this person have benefits. We're awarding benefits based on two people. There you go. And then somebody comes by and says, well, I don't like how you split that up. I can review a federal agency's decision. The state can review United States decisions. This is crazy. This is like insanity all over the place when it comes to the way the United States work. Okay? This trumps this. States don't trump federal. What the hell did Congress do? They ripped them a new one on this. Okay, so the jurisdiction on establishment, they could establish, they could do anything they wanted. They had the authority to do anything. Now, so the question becomes, now that they could establish that you owe this money and that the money is going to be done this way, and again, they're making a benefit decision. It's not actually a child support award. You signed a contract saying the United States is going to take care of you and your kid. They're just deciding how much of the United States money is going to go to each person to do that job. All right? So it's not that they're, they're making a child support award. They can't. That's done. They can't do that. But they're making a benefit decision of how the United States is going to take care of you. And that's not good. So now that they've established this award, okay, and they've created it, now they can enforce it, okay? And the Supreme Court explained this again, because in 1950, they didn't have any consent statements in the law that said that you could send a garnishment to the United States or anybody. They didn't have anything like that. So they said in Wisner, no language existed. And the court unanimously agreed. The Supreme Court in Rose v. Rose said, if this language doesn't exist, you're screwed. You can't do it. State, get the hell out. You can't do it. It's seizure. It's extortion. It's wrong. And they agreed unanimously. Yes, it's in there, and it says that. Now, when you enforce and you send garnishments, the court said, well, the way Congress set up garnishments and to assign permission and consent, the first thing you have to have is consent with a very special phrase. It's called notwithstanding. And basically, it means in spite of. And it means, it's kind of like saying the tree is notwithstanding the wind. It fell over. The wall is notwithstanding this law. So this protection is notwithstanding the force of this statute. This statute can mow right over it. All right? So this is an exception to this. Okay? So here's the question. Does the exception apply? Well, the consent to withholding, notwithstanding this, was governed by two laws. 42 U.S.C. 659 and 42 U.S.C., they were together, 662. And the court was very specific about the difference between these two, because one of the things that the state, there were other people who posted briefs to the United States. This was a big argument just between this, and everybody was fighting over it. So all kinds of people sent in supportive briefs or disagreement supporting briefs into the case. And so they were answering a lot of this. And they said, okay, we're going to be very specific. First of all, a bunch of you guys got this wrong. First of all, this is, again, only enforcement. It says that it applies in any process of law, but it's any process of law in the nature of a garnishment. It says right at the top, consent to withhold and garnish. That's it. So that set the scope of this law. So you cannot say this grants you the authority to establish. If you're in Michigan, your Michigan Attorney General is retarded. He literally says in his book that he wrote, this grants the states permission to establish the support awards with these funds. The United States Supreme Court explicitly said, no, it doesn't. He's in direct violation of the binding authority of the United States Supreme Court, who told him, no, it does not. Okay? So, this law, they said, first of all of this is just enforcement. It's in the nature of a garnishment only. Second thing, 659 is only when you send a garnishment to the United States. It's who it goes to. They said 659 only applies. Rose tried to use some of the little filters that would say that he wouldn't get hurt for the ones that go to the United States. No, they said, no, that's not the garnishments to you. This is just the United States. It only applies to the United States. Very clear on that. Very clear. Then they said 662 lets you garnish directly to the vet or their bank And if they don't pay it, you can hold them in contempt of court, put them in jail, whatever you need. That is the law that let them do it. They were given permission, notwithstanding this, saying that it would be void to do this. And they unanimously said, if this does not exist, it is seizure, it is held by supremacy, and it is void. All of them agreed. It's in Rose. So again, Rose, it's scary because they use it and they say, well, they said the law says this. And you go, you know what, idiot? Did you do your due diligence? This is the first thing you say to these idiots. Did you do your due diligence? Because like I said, Congress changes laws all the time, and Congress responded directly to this. So the law doesn't look like this anymore. It doesn't say this anymore. So we have to look at the new law. And the Supreme Court said, only if the law looks like this are you allowed to do it. And the law doesn't look like this anymore. So your precedent that you say that you have that says that you can, says only, the Supreme Court said only if it looks like this can you do it. And it doesn't look like that. So you don't have a precedent that says that you can. The Supreme Court also said if it does not look like this, you can't. And it doesn't look like that. So guess what? You actually have a precedent that says you can't. What did the Supreme Court do? Well, what did Congress do? You know what Congress did? Again, this was not because of a fight between family law. This is not a family law argument. This is an argument about whose job it is to make sure that we care for vets and their family. Whose job is it? Well, you know how much I hate Democrats and 200 years of well-documented history of them trying to steal from veteran benefits, which, by the way, goes all the way back to 1818. I'm going to mention this one. When state court judges, if you bribed them enough money, would write a letter to the War Department saying, this person is a veteran and disabled, give them money. You could bribe a state court judge whose opinion was held in high regard by the VA, not the VA, but the War Department, and they would send you benefits. It's called stolen valor, and it's where it originates, from state court judges. All right? Well, guess what? And yeah, that's why we get kind of pissed off when people pretend to be us, because they get access to the base. They get access into the commissary. We've had guys trying to get into the hospital. Yeah. Oh, yeah. Okay. Well, actually, I shouldn't read the 42 part. I'm going to erase the bottom one. You know why? Because they deleted it. They ripped it. They repealed it. It's gone. Okay, so as far as garnishing a veteran, telling you that you have to pay the money, even if they sit there and say, you know what? I know that you said that your federal benefits are the only source of your income, and I'm not telling you to pay using those funds. I'm just telling you have to pay the support award I created. And I'm not saying I'm calculating it using that money. I'm just creating a support award. I can do that. And I'm saying that you have a financial liability of $500 and you're going to pay it. And if you don't pay it, I'm going to put you in jail. Guess what? That's what's called doing indirectly what the Supreme Court told you you cannot do directly. They said that's seizure. You can't pretend. You can't pull that crap. The United States, just like a bankruptcy, that debt is waived. You can't assign a support award to them because their family law debt, their financial responsibility to their family, the financial responsibility of the veteran is gone. It is gone. It's like bankruptcy. You've been waived, and the state cannot sit there and say, oh, well, you still owe the credit card, even though the federal government threw your credit card debt out through the bankruptcy. No, the state can't override that. You can't. You can't just pretend that a family law debt exists, because it's not. It was waived, and the United States accepted it. So you can't just do that. Yeah. All of your little silly arguments, they don't fly. It's in the brief. So here's the thing they did. So first, when we look back at garnishment, it's gone. So the only place that they can send a garnishment to is the United States. And trust me, the VA, if you send them a garnishment, first thing is they can only take it if it's money that used to be retirement. And since we're phasing out this waiver deal where you have to give up your retirement to get veteran benefits, there's not going to be anybody left getting these. So garnishments are going to go away altogether because nobody will be getting the funds that they allow. Okay? Under 659, it says specifically, if you're not getting the money under a waiver of retirement, you cannot. So they've been told specifically under here, you cannot garnish these funds to the United States. And you have nothing that notwithstands 5301 letting you send a garnishment to a vet. Now again, that's void. It's void. They cannot enforce it. But the difference is you have to tell them it's void. If the court's telling you to do something and you don't tell them it's void, they can keep doing stuff. And, you know, we have those garnishments and everything, and they go to the bank, and the bank can say, hey, this is void. I now can say that. And they tell the court in response, this is void. I don't have to follow you. You have to, you know, instead of getting dragged into court on contempt charges and all the rest of this, and then showing up and saying, hey, this is void, proactively send this brief and say, yo, get off my back. It's void. Okay? Now, you heard me before. They rewrote this thing. We put in the Veteran Judicial Review Act. And this bulletproofed this thing. The new law is called Title 38, United States Code 511. Now, why? Now, in Rose, this used to be called 3101. Now it's 5301. It's 511. Okay? It's 5301. Why is the new numbers? Because, again, this was what created corruption from FDR trying to steal all our funds. And the Democrats kept trying to do it, and it created an iron triangle inside the VA. We nuked the VA. It was called the Department of Veteran Affairs Act, and we nuked them. We had the Department of Veteran Affairs Codification Act, which renumbered everything and rewrote all the rules and did all this stuff, and they revamped the entire thing. They even wrote the Veteran Judicial Review Act. And again, this was all, we've been yelling at the VA about not making good decisions for 35 years. But as soon as we found out that it was happening to our kids, we were banging on Congress's door. They don't have to give our kids benefits. We're going to smack you upside the head. We've been arguing over whether or not to hold the VA accountable with due process, full due process with courts and special disc. We argued over it because due process takes a little longer. If you go apply for Social Security or SSI, it takes like 45 days. It takes us 2 years because of due process. Well, technically it shouldn't take more than about 90 days, maybe twice as long as it takes to get Social Security, but the VA is a piece of crap and they're slow. So yeah, and they don't want to do their job. They still don't want to do their job, which is why sometimes after like 6 years, we've got people who waited 6 years, you have to do like a writ of mandamus, order the VA to do their job and get the court to yell at them. Now, the way you do this is what they did with this language. Instead of having just one sentence that talked about review, now we have 2 sentences as part of 511. The first sentence has to do with making the decision, and the second sentence has to do with who's allowed to review those decisions. So making a decision, the secretary of the VA shall, this is a big word in the law, and because you can say shall, can, will, may. Those are completely different words. They mean different things. Shall means you will, and it's going to be done in a timely fashion, and we provide time. Will just means you're going to do it at some point. Can, if you feel like it, you can. See, they're different things, and they're semantics, and lawyers are 2-year-olds. Shall, you're going to do this. You shall make all decisions of law. Okay? All of them. Nobody else can make them. You make all. They've now said that the jurisdiction is now fully encompassing all decisions of fact and law that affect, again, you can't piss in the general direction. If it affects the wind coverage of the stream of urine, you can't. No, they have to do it because you can't blow a breeze over this thing. No, that affect the provisions. Provisions is a different word than providing. And some people will tell you that it just means laws. It kind of does. It means any law anywhere. You're not specifying a title. Title 38 is a book of laws that have provisions in it, and then we separate by chapters. But it means all decisions of law that affect provisions anywhere else in the law. If it's under Title 42, this decision now has to be made by the VA. This is a Department of Health and Human Services law. This is under their code. VA makes it. You could have laws anywhere else. It's like this so much that in here, under Title 38, they had to write a law that said, yes, the VA's focus is Title 38. So if it affects a provision outside of Title 38, then we're going to allow the VA to ask the Attorney General for help understanding that area of law so that they can make the decision. They can ask for help, but they still have to make it. Yeah, it is fully encompassing anywhere in the provisions of benefits for veterans, their families, and defendants. They shall make them all. Exclusive. You want to know how exclusive that is? How broad that includes when they say the provisions? If it's a constitutionality question, they have to make it. Is this law constitutional? The VA has to make it. You have to ask them first. If it's a tort question, the VA screwed up and we got hurt because of it. It's malpractice. It's some tort question. No, it's them. Bivens. It's under there. It doesn't matter what kind of question. You're going to go to the VA. They can't make anything. Doesn't matter what area law it is. Doesn't matter if it's who gets how much anymore. No. Who gets how much? That's just the benefit decisions. Anything around it. They can't come near us by 100,000 miles, people. Okay, now the review. The review no longer says of the United States. It says any court or official. Any court in the United States, any official in the United States. You're not allowed to review those decisions, and they have to make them all. Now, again, we like showing case law because it's like, you look at this and you go, okay, so Congress changed the law. We have a precedent that said that the Supreme Court said the old law said this, but how do we know how effective this new law is? You want to know? First of all, we look at Congress. Did Congress mean to strip state courts of their jurisdiction? Check the brief. It's in there. Congress specifically stood up and said, oh, hell no, they are not going to have independent authority over veteran benefit decisions. They are not going to make them. They are not going to smell at them. No. Congress actually very deliberately, with intent, enacted through positive enactment, stripping them of all authority of review. And it started off, it's like on page 19, it starts off saying, no, they are not going to be making any decisions, and nobody is going to do the review except for the special courts that we put above. We are creating a brand new set of United States Courts of Appeals. Think about this. We have federal circuit courts. Those are the numbered courts that we talk about. It's like, Circuit 1, I'm in the 9th Circuit. You have the 8th Circuit, the 6th Circuit, you get Kentucky, you got the 2nd. All these different circuits, and underneath the U.S. Circuit Courts of Appeals, the circuits are the appeals court, you have district courts. And so you can't have a district court make a decision and then, you can't have an Oregon district court get appealed in the 4th Circuit. They can't do that because that's not there. They've been told they can review. Making a decision has to be reviewed, but make it by the district, reviewed by the court, the circuit above them. So those courts of appeals, we already had all this. No. Think about it. We got a lot of veteran claims. We got a lot of kids. They get to sue the United States, and the VA are dumbass idiots. They don't want to do their job. They will lie. Chief Justice Marshall, like a year ago, I think it was, maybe 2 years ago, sat there and was talking to the lawyers over on the VA thing, and they said, at the appeals court, and they said, wait a minute, because after you're done with the VA Courts of Appeals for Veteran Claims, you can go to the Supreme Court now. You used to not be able to do that. The Supreme Court was going, wait a minute, let me get this straight. 70% of the decisions that the VA makes are substantially stupid, okay? They are absolutely, without question, there is no reason at all. The VA has, they look at the thing and everything says these people should get benefits and they have no reason to deny them, and 70% of the cases they say screw you for no reason. They don't even give them a reason, even a fake reason. They have no substantive reasoning at all. And then you have 30% where they actually gave them a reason, and a bunch of those get overturned anyway. This is stupid. Oh, they were pissed. The VA is still stupid. So, we have the U.S. Court of Appeals for Veteran Claims, all brand new United States Courts of Appeals. We also have the Federal Circuit. The Federal Circuit, like if you sue the VA on an administrative question, these tort and Bivens questions, things like that, those, when you sue the VA for failures and pain and suffering and stuff like that they've caused versus a claim, those, when they get appealed, they go to the Federal Circuit. So like if you were suing the U.S. Attorney, or you're suing the President, or you're suing somebody and you have a waiver or whatever, those appeals go to the Federal Circuit. So the only people who can review the Secretary's decision, if it's a benefit decision, U.S. Court of Appeals for Veteran Claims. If it's one of the other ones, it goes to the Federal Circuit, and then above those two, Supreme Court. They're the only ones. It's exclusive. Every United States Court of Appeals, the numbered ones, the Veteran Claims one, the Federal Circuit one, every single court has said this is exclusive to the United States. You go to the Department of Veteran Affairs website. Go in there and do a search. Just go to va.gov. Do a search, quote, exclusive jurisdiction. Do a search. There are 70 articles written, not just by the top performing lawyers in veteran benefit law. Okay? These are approved legal documents by the Secretary saying these are correct. These are good. These things are written by the people who are part of the Board of Veteran Appeals. This is the guys inside the VA who make the very last final decision for the Secretary. These are the Secretary's very own people who make this for him. They wrote these things. This is the Board of Appeals, exclusive jurisdiction. So the VA has said exclusive. Now I know you can call up and somebody at the VA is going to give you like a verbal. They're idiots. They lied. If you can prove that they said that, you can sue them in a tort claim for saying it, because they're in violation of the binding authority of the courts above them. The Federal Circuit and the Courts of Appeals for Veteran Claims have all said the numbered circuits don't count because they don't have to deal with those. But the other ones that are above them, they said it is exclusive. They told the VA, this is the opinion. You're not allowed to say anything other than that. You have to say our opinion, you're wrong. So the VA does this little thing because, again, they don't want to give your kids their benefits. They don't want to do the job. And the best way to not do their job is to let the state screw with you. All right? So, yeah, and by the way, hey, VA, guess what? You're in D.C., and I'm in Oregon, and you know what those are? That's called a single consent states. And the federal is single consent, which means I don't have to have been telling you when I record my conversations with you. So every single time one of you said, yeah, they can do it, guess what? You just lied on behalf of your clients. You lied, and I've got you. Especially, oh, I love the ones when I sit there and say, well, the Court of Appeals above you said it's different, so why are you saying something different? And then you like hang up on me. I love those ones. every single one of you are going to be on my defendant list when I go to the courts on you, because when I'm done with Oregon, yeah, I got 24 judges I'm ripping robes off right now. I'm going to go after the VA after this, okay? So, yeah, no authority. Yeah, every United States Court of Appeals, the VA, although they'll tell you verbally, all of the documents, the legal documents that are provided as the Secretary's opinion, all agree with the U.S. Courts of Appeals, and they say, yes, you're right, it's exclusive. In writing, they say, yep, it's exclusive. The Treasury, as part of the executive branch, has sent down messages to these people saying, yes, it's exclusive. As a matter of fact, in those little regulations that they told them, you can't garnish this, they wrote down, they said, the veteran can take this into the court and tell you, go the hell away, on a child support garnishment. You can go back to the court and tell them it's void. You can declare your protections of 5301. Yeah, even the Treasury tells you to tell the state that their judgments are void. Congress, the executive branch, and the judiciary have all three declared exclusive jurisdiction over the sovereignty of the United States for the waivers provided to veterans and their families to sue the United States against their sovereign indemnity. The states are declaring unilateral authority over the sovereignty of the United States. Now, people keep asking me, Peter, why is it that you're authorized? You've mentioned this before and you don't want to give us a list. You keep saying that. I'm not going to give you a list on how to build a bomb. Sorry. Do I know how to do it? I could know how to do it. I don't want to build a bomb. I don't want to go bomb somebody. I don't want you doing it. I don't want you doing violence, so I'm not going to give you a bomb list. Okay? I'm not going to give you a list. I'm going to tell you this is one of the steps. This is one of the things I did. I'm going to do like Mythbusters, and I'm going to sit there and go, put a little of this, a little of that, a little of this, a little of that. I went through all three branches. I went through the judiciary in the courts. I went through the judiciary in the administrative side. I went through the legislative side of Oregon. I go ask Senator Boquist and House Representative Valentios, and I put bills in the thing. I went through, and they denied my right to protest. Oh, they kicked me out. They said they would not let me come in. All three branches did. The executive branch, they've told me the same thing. They won't allow me to protest, won't let me do nothing. They've been following orders even after I told them they were void. I went through everything, and I followed every legal due process. Every single one of them failed. Every single one of them, I showed them that they were void and that they had no authority. They did it anyway, and as a collective whole, all three of these have declared unilateral authority. So why? Because of about 8 years worth of work, people. And I'm telling you that most of the judges out there aren't schmuckos like the ones in Oregon. Okay? Most of them. Just like we talk about the police. Yeah, sure. I'm sure you'll find a bigot in the police department somewhere. I'm sure you can find a couple of them. I bet you can find schmucko judges. You can find a bunch of judges. You know what's going to happen when you show this to most of the judges out there? I've had one case where somebody submitted it and the judge went, I'm not going to read it. And he literally just walked away. He did not answer it. That's the only thing I've had. I didn't have a judge say, screw you, I'm going to keep doing this. He just said, I'm going to pretend I'm not even looking at it. And he walked. They never answered the brief. They submitted it, and the court just went, I don't see it. They put it on the docket, and there's been no answer to it. That's the only thing. And there's ways to deal with that. Okay, there's a writ of mandamus, there's defaults, and all kinds of things, and there's a way to help this guy, and I'm working with him. And trying to explain, there's these processes that you can do. Okay, but these are processes. These are the first processes. So again, if you're thinking about pointing that gun at yourself, I know they're trying to tell you that the only way you can stop them is to pull the trigger and kill yourself. Guess what? I'm telling you, you don't have to pull the trigger on yourself. You can stop them. You just got to get them this information. You send it to them, and it's void, and you rip that robe right off them, and they don't want to rip their robes off. Most of them are pretty smart. They're not even jerks about it. They're just like, yeah, that's the way it is. Okay? So You don't have to point the gun at yourself, and you don't have to get so mad you want to point it the other way. Because most of the time, this is going to deal with it. All right? There's guys like me, and I appreciate all the support from everybody saying, yeah, you should just go do it. And yeah, I'm thinking about making a little bit of noise about it. But at the same time, no, I don't want us to do it violently. I don't want to turn into like, oh yeah, we're going to go protest, but then we're going to go break buildings. I'm going to tell you right now, if you go do a sit-in at somebody's office, if you go do a protest or sit somewhere and do your little protest and you get arrested, guess what? That means it wasn't protected by the First Amendment. It's not a protest anymore. You did something illegal. You're doing something violent. You're destroying buildings. That's not the answer. And that's been the whole thing about what's been going on over the last couple of months to the last year. It's just, look, we are so tired of lawlessness. We're tired of people just doing anything they want. And this is part of it. These are judges in Oregon that said, I don't care if you told me that I don't have authority. I don't care if Congress threw my judgment and voided it. Screw Congress. That's what they did. They said, screw the U.S. Congress. Okay? We're not going to fall for that crap. We're not going to be violent. So, again, don't be doing that. Don't pull the gun on yourself. Get to protect veteran benefits. Get this motion. Put your name in it. Fill it out. Do it. Show it to your lawyer. The lawyer's going to go, oh my gosh, we've had all kinds of people look at this thing and go, oh, this is going to help us in our area over here that's just kind of close to it. This helps us get it in to fix our problems. Okay? Spread this around. Tell vets. They're hiding. These people have been beaten down and they're hiding and they've been extorted from and they're being threatened with jail. They're hiding and they shouldn't have to hide. These are people who look at this and go, how could my government do this to me of all people? They're going to do it. So, and again, here's to all the former spouses that sit there and go, oh, you're just trying to get veterans out of doing it. No, I'm not. I'm making sure you're getting your federal benefits. Because the only thing you're doing is you're being vindictive and vicious towards your ex. And I just don't have that. I don't have the room for the hate. I don't. I don't care how much I hate my ex, she hates me. I don't care about it. Okay? The simple fact of the matter is that the United States and the VA has money and they provide it to me. And the only reason the state is taking my money is because the United States sent your support award, your kids' support award, all those support awards to the state. They've got it and they don't want to do their job. They don't want to give you the money. They're keeping it. Okay? Everybody else who's on these federal benefits, all the people we shared these benefits with, the poor, the affirmative action funds for black people, all of this stuff to desegregate, all of that, they're stealing every dime they can get. And it's right there in the congressional reports. Now, snowflakes out there going, I don't want a citation. Get the brief. I don't want a citation. It's in the brief. It's very cited. You want to know about the case I'm doing? It's in the courts. Okay? And I'll talk some more about that. This has been long. I hope you guys have gotten the information. The simple answer is, again, you don't have to be able to explain all this to the judge. That's why I made a brief out of it that does it very quickly, very concisely, and gives it to him. You're not there. When you give this court the brief and they say, we want a hearing, and you walk in, you're not there to debate it. Your Honor, I'm not here to explain the law to you. That document explained it. Now, I don't have to explain it any further. The document provides you an explanation out of courtesy. I don't have to do that. That's courtesy. The document tells you that your judgment is void, and you should know that because Congress wrote a word and wrote sentences there that said, Judge so-and-so, your judgments are void from the get-go. So I'm not here to argue it. You want me to explain it to you? Read it. I can't explain it any better than that. You don't have to. You don't have to know all of this. Okay? It's good to have an understanding, but you don't have to get super analytical and learn how to teach some judge who's got a judicial doctorate and should know. Yeah. You don't have to. Judge, the explanation isn't required. You've been provided the clearly valid statute that deprives you of all jurisdiction whatsoever and voids your judgment. We're here to deal with how to deal with this in a legal way, because so far we don't have a legal judgment. We need a legal judgment that was not made way back when, because it's void from all the way back there. So let's go back, and now we're going to make a legal judgment, which means I don't have any income, I have veteran benefits or Social Security or both. You don't get to use that. So without a form of income, 0% of 0 is 0. Okay? Which means now, in that brief as well, it tells them, any money you took from me, you have to pay me back. Now, former spouses, don't worry, because in that brief as well, I know that the states took the money from the vet and they gave it to you. Those are two different things. One is taking money. It says that the state has to give back your ex all that money. There's another piece that's in the brief that says, guess what? The state cannot forcibly take the money back from you and your kid. They can't force you to pay it back. Congress has been dealing with this forever, and they wrote that specifically. The state is going to get left holding the bag. They screwed up. Those judges screwed up. It's going to come out of their pockets. It's going to come out of their salaries. It's going to come out of their stuff, and the state's going to have to figure out how to do it. They want to turn this into a dog pit. That's what they did. You want to know what the Rose v. Rose case was and why Congress got so pissed? Because Congress stood up and said, we are not going to have veteran benefits done in an adversarial situation. When you walk into a divorce court, you're looking at typically a family who has created their family empire of wealth and property. And now you have two people who disagree on how to split that wealth and property. You're a veteran, and your family and you don't have a wealth of property. You don't have a kingdom of wealth and property. You have a hole in the ground. You have nothing. You're on federal benefits for your welfare. You're on welfare, people. You're in a hole. You have a judge standing there, and you know what it is doing? He's holding your federal benefits up like a piece of tasty meat for both of you. And he's got this lawyer on this side and this lawyer on this side, and they're cattle prodding you like dogs in a pit, fighting over a scrap of meat. And every time one of them wins a little bit of an argument, he tears off a piece of that benefit and awards legal fees to these two guys, and he keeps a little for himself. Yeah, he does. That's what he's done to you. You're dogs in a pit where they've turned your kid against you and dangled a little bit of meat, what you need to survive. They're dangling your welfare, your livelihood, your ability to survive over your head, going, go ahead, fight, kill each other, come on, who's going to win? Oh, that's a big guy. Let's stomp on the vet some more. And we're going to take custody away because we've got to have this nice fight. Can't get the fight unless they're separated. Come on, fight, fight. Guess what, judges? I'm pissed. Every veteran nationwide should be pissed. Every taxpayer who paid money into the system to care for veterans and their families, where your money isn't going to them, it's going to stupid idiots who's stealing it, you should be pissed. It's time to get them back. Everything's been lined up. The laws are there. It's time to mow them over. Come on over to Veteran Benefits. Protect Veteran Benefits. I'm going to do it. It's on Facebook, in case you don't have it. Go to facebook.com/protect veteran, all one word, veteran benefits. I can't spell right today, sorry. There's only one S. Protect Veteran Benefits, okay? On the front of the page, there's a contact us that's going to take you to the group. There's the files. The files are in the groups, because that's how Facebook does it. Okay, or you can just go to facebook.com/groups and it'll take you here. But I'd like it if you go to the page, like it, share it, get this out to those other vets. We've got an answer. It's there and it works everywhere. So come and get it. Thank you. I'll leave you with that.